thank you everyone for being here. It just feels wonderful to be with everybody. Daryl, like he said, we started talking about this over breakfast or drinks or something a number of years ago, and we were able to produce this in 18 and 19, and due to COVID, of course, you know, even though we tried and we have a great team, all these guys around here helping us, we couldn't do it in 2020 and we couldn't do it in 2021. So we're thrilled to be here. And I guess if I could, just to acknowledge that moment that a lot's happened in the 2 years because of COVID. And so maybe we should all be really thankful, gratitude that we are all here. And maybe we can have sort of a moment of silence prayer for all the folks who have suffered, you know, COVID, lost family and everything. So I'm going to ask us to do that just for a moment. And also, you know, taking into account, I guess, local events, all the tragedy, you know, down in Arabi in the 9th Ward in the West Bank the other day with that horrific, wicked tornado. So can we just have a moment to just be thankful and some prayers and think about all that? Okay, so on with the show. So it's entitled, you know, our 2022 Cybersecurity Liability Update. As Daryl said, buckle up because it's a lot. I have to give this disclaimer that nothing here is any kind of legal advice, any kind of other advice. I'm a lawyer, right? I got to do this, right? So nothing I say is advice. You can't use it. None of that. There's no attorney-client privilege. That's what the black box says, right? So, and several of you here who are my clients, don't say anything, right? This is not an attorney-client privilege setting, right? All right. So buckle up. We're in the fast lane. There is a lot to cover over 3 years, right? Because we were last here in 2019. So I'm not kidding. There's a lot to cover. It's sort of like drinking from the fire hydrant, right? And Daryl and I obviously on the same page. The statement, you know, from the White House about where we are with Russia and what they're planning. So you have no better place to be than in this room today, I think, and listening to these presentations today. Why is data so hard? Why is data security so hard? Well, here's the chart, right? Billions of Internet of Things devices all over, right? It's not going away. It's only going to get worse and worse. What are really the two issues here, right? The issues are privacy rights and security, right? You can sort of think of them that way. There are rights to privacy that consumers we're mainly talking about here. This is not so much businesses, but and then how do you protect that? And what are those laws and how do they vary from place to place? So since we last met in 2019, of course, we had Mark Zuckerberg and the Facebook Cambridge Analytica incident. They eventually, you know, were fined $5 billion in that, which some people would say that's a slap on the wrist for Facebook. Whether it is or not, you can judge. And since then, we've had, you know, COVID. We've had the California, the CCPA, and it's going into effect. And in the middle there, which you may not know what that is, but that's our indication that there's something between the European Union and the United States called the Privacy Shield, and it got blown up, which is a way to protect the transfer of data from across the Atlantic to the United States. And that mechanism, which is very important, is no longer in place. So that's just a few of the highlights. So here's the overview. What are we trying to do today? We're going to do this overview of the GDPR, the European Union law, because it is what's driving a lot of these changes and has been driving these changes for the last, I guess, 6-7 years. We're going to talk about the response of our federal government and the FTC role. We're going to talk about the response of our 50 states, California, CCPA, and some others. We're going to talk about privacy policies. All of you may have a privacy policy, maybe you don't. Do you know what's in your privacy policy? We're going to talk about American businesses and the GDPR and the collapse of the Privacy Shield and a few other things. Number 6, we're going to talk about the outlook on the federal front, what's going on in Congress, what's coming, what's not coming, and what should you do, sort of the risk assessment, and I always go back to the NIST cybersecurity framework. So, quick overview of maybe not so quick, of the GDPR, right? Sort of an integrated, system, everything working together. That was the design of the GDPR, right? So this sort of, Swiss Army knife that has all these things, but it's all sort of working together. One tool, many functions. It's all about consumer data. So what's the U.S. look like, right? Well, this is sort of the U.S. approach, right? We've got all these different federal statutes. The main ones, you can count 20 at least, and there are many, many more that deal with privacy or security. So a problem for businesses, in general. So what is the GDPR? For those, I know we have a wide spectrum in here from novice privacy policies all the way to very sophisticated, so trying to talk to the whole group. This began back in 2006. It was passed in 2016. It's effective March 25th, 2018. So 4 years ago, right, I guess. And it regulates the processing of data. But what's the point, right? What is it about? It's all of these fundamental data rights. If you think about it, it's sort of like the Bill of Rights in our U.S. Constitution, but it's about privacy. It's about data. And these 8 rights are the fundamental rights that came about in the GDPR. To be informed about your data, of access to your data, to rectify your data, to erase your data, right? To restrict processing of your data, to data portability, to object to what's there, and then to a relationship to some automated decision-making and profiling. Think about like coverage for insurance or healthcare or whatever. So, and what's the sort of the terminology? You're either a data controller or a data processor, right? That's the terms of art in the GDPR. The data controller is, I'm the one who's getting the data. I'm the one who wants the data. The data processors are those other partners or whatever you want to call them who help you process the data. And there are different rules depending on whether you're a data controller or a data processor, right? Consequences for violating the GDPR are huge, right? 20 million or 4% of the gross, right? Not 4% of your profit, 4% of your gross. So just think about what that does, as I always say, to the margin in your business, right? And the potential consumer liability. Does your business have to follow the GDPR? You're probably, many of you are thinking, why is Ray talking about this European law, right? Well, one, it's the model that everybody is going to in some way, so it's sort of the future, but it's here today. But second, there is really liability today. If somehow data, and I always say follow the data, if data from the European Union is coming over here and you're doing something with it from a European resident, you've got liability, at least per the literal terms of the GDPR, you have liability if you're not complying with the GDPR. And it's not easy to comply with the GDPR, especially if you're not thinking about it. So do you offer goods or services to EU consumers, right? Maybe you're pricing your goods with, European dollars, right? Do you monitor the citizens, right? So you catch an email address when someone's at your business and they go back to France and you start sending them information. You're collecting data. I mean, you might not even be thinking about it, right? But you're collecting data on a European citizen, and you, at least by the terms of the GDPR, are under it. So here's an example. This is an application called Grindr. Was targeted to the LGBTQ community. They were fined in December of 21 for $7.2 million. And they have 200 people working for them. They're in California. You think, well, they certainly know what's going on with the GDPR, but they were violating the GDPR all over the place. So they were tracking their users. They weren't given the right notices. So lots of violations. So that leads to, well, what might be something you need to do under the GDPR, right? Well, you need to think about, do I need a DPO? Do I need a data protection officer in my company, in my business? And according to GDPR, under certain circumstances, you must, and of course, it's the best practice to have one anyway. What does this DPO person do, right? They're the contact when the consumers, which are called data subjects in the GDPR, they come to figure out, hey, how much of my data do you have? And I want to do something about my data. They inform the organization. They're supposed to be the education czar for the group, and they monitor compliance of the organization. They do some kind of impact assessments, whether that's pen testing or whatever they're doing, and they ensure cooperation if they're being investigated, and they represent the company, as opposed to when they're dealing with the EU. So who needs a DPO? Certainly public authorities, large scale, whatever that means, regular monitoring of personal data or large scale special data. So there's some definitions, that different countries over there have said what's large scale. For regular monitoring, number 2 here, of personal data, that means your core activity of the organization is processing data. Well, there's a lot of organizations that would fit within that, right? Especially today. How can anybody do anything without processing a bunch of data? But certainly think of a bank or hospital or an insurance company, right? That's what they're doing. So what are these limitations that the GDPR imposes, right? That you can collect only the minimum amount of data. And that concept, minimization, how much data do I really need to collect? And what's the fuse on that data? How long do I need to keep that data? If you're not thinking that way, then you're not in the GDPR. And what we'll see for the CCPA and some other California statute and some others, that's the mindset that we all need to subscribe to. So what are the lawful purposes? Well, there's opt-in. There's a big debate over, is it opt-in or opt-out? We could talk about that for a whole day. Necessary to save a life and some others, right? And you have to give consumers notice. I mean, a lot of this is about transparency, letting the consumers know, what are you doing? And telling them in advance, what are you collecting and what is the purpose? What are you going to do with that data? And the accountability of protecting the data. So if you think about it, you have to consider the legality of each and every data transfer. And that's mind-boggling, but that's what you have to think about. And so as I say, I've always said, follow the data. If you're not following your data, you can't even begin to grasp the issues that you have and define the problem, right? How can you fix the problem before you understand the problem? You need to be able to prove continuing compliance. And don't take that lightly, because putting in the right controls, and I'm sure we have some folks from accounting and regulatory, even if you're doing the right thing, if you can't prove you're doing the right thing, right, you're in trouble, right? So having those the adequate controls in place is just as important. You have to report data breaches within 72 hours, and you have to design on the front end, right? It's preaching. When you design your products, you have to collect only the information possible. You got to build that into it's not an afterthought. It should be built in on the front end. And how can you consider all these transfers if you're not mapping your data, right? And there's a lot of vendors, some we have here today, who can help you with, figuring out how do you map the data, right? But you have to at least start out, mapping your data. And as I say there in red again, follow the data. Follow the data. So who's been fined? Mostly the big fines have been against American businesses. You can probably identify the culprits without even me putting this slide up here, right? Amazon, WhatsApp, Google, Facebook, big numbers for us. Maybe those aren't that big of a number for some of these guys, right? 877 million, 255 million, 240 million. So not chump change. So go back to the response, of our federal government. We got, Fair Credit Reporting Act. We've got HIPAA. We've got GLB, right? We've got 50 states and database breach laws. We got the CCPA out in California now, and we have a few other states that are cloning. They're cloning somewhere between the CCPA and the GDPR. Colorado and Virginia in particular are about to come online here in the next 12 to 18 months with their statutes that have been passed. So who's enforcing? If you never heard of these guys, then, hear about them now. Federal Trade Commission, they regulate a lot, but they have a huge role in the data privacy sphere. They are probably the default regulator, not to say that, financial regulation, although FTC has some regulation, some authority under GLB, but you have, others in the financial regulatory scheme who have authority there as well. And then, of course, HIPAA has its own with the Department of Health, Office of Civil Rights that they regulate. But still, FTC regulates a lot. As I say, they have a lot of bats that they can carry, and they are not shy about swinging their bats. And they like to make examples of people. And we'll talk about consent decrees, and they post those consent decrees on their website. So if you really want to know what's going on, the FTC, just go to their website and look at all their consent decrees. So, but they have other authority under, like the CAM-SPAN Act. They have some under GLB, the Children's Online Privacy Protection Act. They have some authority under the Fair Credit Reporting Act, so that's, Equifax and those guys. The FTC's authority is this catch-all under their unfair or deceptive trade practices under Section 5. It's not as if the FTC Act talks about privacy specifically or data security or anything like that. They're just using sort of their larger power in these words, unfair trade practices, unfair or deceptive trade practices, to do what they're doing. And they got a lot of authority and power because it's been challenged, and the FTC has won. So first-time violators, however, cannot be fined, and we'll see a lot of that. Some of those other laws, they have specific authority to fine you on the front end. But a second-time violator, and that's sort of how Facebook got hit up with their $5 billion, because they were under a consent decree from 2012 and violated it, and so they could rack up these daily fines over a long period of time. And they're getting creative. They got an executive order from the White House back in July of 2021 to get more aggressive on data privacy, mainly, I think, because of everything that's been going on, and we'll talk like the Colonial Pipeline and some other incidents, and because Congress can't seem to pass any kind of legislation. I can tell you there's been federal legislation proposed at least in the last 7 Congresses, so that's 14 years, and we don't have it yet, right? Maybe this year. Everybody says, oh yeah, this year's the year. Well, I heard that after Equifax. I heard that after Cambridge Analytica. I heard it before that, so I don't know. And it's not like there's not a lot of other stuff going on in the world, right? So what happened in this FTC case, the RCG advances, why am I talking about this? Because the FTC got creative because these guys were saying, hey, you come to us, we'll give you credit advance, sort of consumer credit thing. And we said, you don't have to no upfront fees or no personal guarantees. Well, that turned out to be a lie, misrepresentation. And so not only did they fine them for that deceptive practice, but the key is they went under GLB with the authority they have there, and they said, and we think that you're misrepresenting things to obtain financial information. So they're using that hook now to expand. So that's sort of a new tool in their box. What's their recent focus because of COVID and some other things, right? Health app data, and we'll see one example of that in particular. The accuracy of the data used for housing, employment, and credit, and of course video conferencing, right, and educational tech, right? Think about what's happened in the last 2 years with that. And the social justice issues, tech, which exacerbates racial disparities, or guidance on AI and algorithms. Credit disinformation, and affirmatively studying the effect of privacy practices on minorities. So again, it's deceptive or unfair. They got to fit in one of those 2 buckets when they come after you. Commonly what happens is there's some sort of administrative complaint. They're investigating you. They're working it out with you behind the scenes, and then after it's all sort of a done deal, they go in and file a consent decree, get the court to approve it, so they got you under the court, you're under the jurisdiction of the court now, and this is the key, they got you 20 years, you're under a consent decree. And that is how they get you, 20 years. And if you violate, then the 20 years gets like reset. So you really got to be on your best behavior, and the fines are huge or can be used, right? So, but that's how they work, and it's very effective for what they're doing. Whether it's effective in regulating the privacy security world is another debate, right? Which is probably why, a lot of people say we need a more comprehensive federal solution. But anyway, the FTC is doing what they do. So here's an example of deceptive practices. The Ever album guys, what they were doing is they're taking all these photos and they're behind the scenes using all these photos of everyone to create their own facial recognition algorithm, and they're updating and getting it better. And then they go sell that facial recognition algorithm and making money. And of course, their privacy policies basically didn't say any of this or disclose any of this, and said, oh yeah, when you delete your photos are gone, but they're still using the photos to, tune and improve their facial recognition software. So two deceptive practices: misrepresentation about the opt-out of the facial recognition and the deletion of the deactivated users' data. And so basically gutted their business. They were required, well, not the total, but a lot of it. They had to delete all their photos. They had to get rid of all their face data, had to get rid of all their modules and algorithms, everything they'd invested in. And prospectively, they had to give notice of their practices, and they're, of course, under their consent decree. Right? And it didn't take that long. I mean, in the legal world, 2 years is not long, to get from media reports to where there's an FTC consent decree filed. And there's class actions. This is not the FTC, right? I mean, you got other litigation going on, right? So here's an example of deceptive privacy practices. Flow was an app that allowed a woman to track their menstrual cycle for pregnancy planning, and their privacy policy said, by the way, they were a first-time violator, so no fine, right? And so they're collecting the PHI, which is the personal health information of all these women. They said they weren't going to do anything with it, they weren't going to share it, and they're only going to use it, to whatever they need to do just to, make their app better, right? Okay, we get that. That's in most privacy policies in terms of service. But their terms of service, the TOS there, right, said the exact opposite. It said that Flow and all their vendors and partners and everybody, they could, whoever they transferred the data to, they could do anything they wanted with it. And they were sharing their, information with Google and Facebook and all sorts of people. And they weren't requiring, they weren't flowing down these contractual responsibilities. So basically, privacy policy says this, terms of service says this, 180 degrees. So that's a recipe for the FTC to come in and pound you, right? So Zoom, right? A lot of this started with the increased volume in Zoom because of the pandemic. First-time violator, though. They're under a consent decree, but they were talking about their encryption. Turned out they didn't really have end-to-end encryption like they were saying. They displayed encryption. They delayed the encryption of the stored videos. So again, they were misrepresenting what was going on in their operations compared to, their privacy policy. Lightyear Dealer Tech, what happened with these guys? Basically, one guy puts in one storage device and doesn't turn on the security controls, right? And the whole thing, runs off the rails, right? So what happens here, right? They fail to use an inexpensive but effective security measures, right? Inexpensive, and that, that's what we have to look at over time. So many of these solutions the price has come down, right? And compared to the liability, right? So they did not train their employees, they did not assess risks, they didn't use readily available security monitoring, they didn't use reasonable access controls, and they didn't encrypt, right? Encryption, right? I mean, encryption really, if you're not encrypting, right, you should be encrypting, right? I go back, I always say when they passed the upgrade to HIPAA in 2009, the High-Tech Act, that's when the government said, we're going to really fine all you guys in the medical healthcare world if you don't comply with these things. But if you encrypt, we're going to give you a pass, because how can someone complain about encrypted data because they can't, if it gets hacked, so what, they can't do anything with it, right? And so they pushed. At that time in 2009, everybody thought, oh, encrypting all this data is going to slow down all my cycle processing, right? I can't do that. Well, so good for the government. They passed that then. We don't even think about it today, that encryption slows things down. I'm not saying it doesn't, but nobody thinks about it that way anymore, right? And so that's an improvement. But if you're not encrypting, you're opening yourself up, not under this statute, but under so many statutes. So what's the consent decree? And I would like to go through this really quick, right? The appointment of a manager to oversee data protection, not too bad. Encryption of all financial information, should have been doing that anyway. Monitoring of all computers and assets in the network. Data access controls, right? Number 5, yearly inventory and security check. May have been doing that, maybe not. Yearly testing and updating of measures based upon results of tests, right? So what's number 5 and 6? It's rinse and repeat, right? Rinse and repeat every year. And that's sort of the HIPAA model that came about in the 1970s. Reevaluate your third-party service providers, right? Because you have liability, or you may have liability for what they do. And hey, to renegotiate contracts isn't not necessarily an easy thing to do, and it might take some time, right? Yearly self-certification, right? And here it is, someone coming into your business, right? Number 9, every 2 years, you have to have an independent third-party certification. Someone who's going to come in and kick the tires and see, are you doing what you're supposed to be doing? And of course, the fines. So that is a model of a consent decree, right? That's what you're facing if you're not complying. A lot of the thumbs on you for a while. So it's only a single employee's mistake, most breaches are human errors, right? Relying on your employee's best judgment, that's not security, right? And you have to renegotiate your contracts, right? Because you're probably liable for what your partners and vendors do. So they use consent decrees to create this common law of data privacy rights. Like I said, you can go to the website, but it's really hard to clearly define those rights because they're just taking it episodically. Or there's incident, and they're saying this. Although, as Daryl said about two-factor authentication or some kind of authentication, the FTC has been screaming that on their website probably for the last 7 years, saying, here they are, and they didn't have two-factor authentication. They were sending that message. They were signaling that you should do that. That's why I say go look at the website, is if you want to know what's going on or what they're asking people to do in the future, what they may be, using one of their bats to come after you, it's somewhere there. It's not easy to find, but read the consent decrees. So we get to the third bullet, right? Is there a need for a comprehensive federal statutory regulatory scheme, right? So we can all debate that, I guess. A word on HIPAA, and I say this too, we have a HIPAA panel later this morning, so for all of you who are interested in that, a HIPAA and a database breach panel. So this is the example of the U.S. piecemeal approach, right? Policed by, the Department of Health and Human Services, their Office of Civil Rights, and those guys are aggressive too. Policy, police is unauthorized disclosure of protected health information, as opposed to, PIIs, PHI. And who does it cover? Health plans, healthcare clearinghouses, most healthcare providers, and their business associates, right? So everyone who's doing business with a clinic or a hospital or whatever, the insurer or whatever. And I say this here because it used to be in the early days of HIPAA that business associates the law said you had to contractually bring them in so you could try to pass down liability. But the Office of Civil Rights, DHS, didn't have direct authority over business associates. But that all changed with high tech in 2009. So if you're working for a clinic or a hospital or someone, whether you know it or not, DHS can come in, OCR, they can come in and say, hey, what are you doing? Are you violating the statute? And you're like, what statute? I just got a contract with those dentists, what am I doing? So that's the way it works. You may be regulated and you don't even know it. Although probably in your business associate degree, you see all the sites to the regulations. So what's the HIPAA rule, right? Administrative, physical, technical control, right? That's still a pretty good way to think about it today, even though HIPAA's, 70-ish vintage, right? So implement measures, reduce risk, right? You gotta have those administrative controls, physical controls, and your technical controls. There's no private right of action under HIPAA, but that doesn't mean you can't use those or try to bootstrap in under some other legal theories and state law. Generally, HIPAA and the state attorney generals can do that. They have their wall of shame where they post all their violations for breaches that are over impact more than 500 people. And the violations, for the last 2 years, you've got, 660 from cybersecurity failures, like Daryl said, right? It's sort of, I don't know if Daryl said exponential, but it's been very hard to get a grip on the explosion in cybersecurity risks and the laws and regulations that are coming about trying to react to it and regulate it, right? HIPAA fines for 2021 were 19.5 million, but we'll talk about a few of those. Here's Premera, almost $7 million, lifetime health care, right? 5.1 million, community health systems, 2.3 million. And you see 10.4 million people affected, 9.3 million, 6 million, kind of today, nobody gets shocked by these numbers. 5, 6, 7 years ago, you said this, people got shocked. Now it's sort of like, oh, just another data breach. So I don't know what that says about our mindset. The response of our 50 states, right? So we have, and this, by the way, is from the International Association of Privacy Professionals, which I'm a member. I assume a number of you out there are. It's a great organization. This is from their website, and it shows, what's going on because the feds have not been able to get a law on the books, right? And you have the GDPR pushing it. California was the first, and now Colorado and Virginia have passed their law. Louisiana is studying it. They have a purple, I don't know if that's Mardi Gras, but they have a committee at the legislative level that's studying it, although, how active they've been, we'll talk about that. And then you have a lot of other states that are thinking about it, right? So what is the CCPA? I've mentioned it several times. It became effective January 1st, 2020, so since the last time we were together. And then it was sort of, upgraded with the California Privacy Rights Act, which was passed in 2020. And we'll talk about what's in those acts. But, how does California influence things? Well, I think we all know that, right? 15% of the U.S. GDP, 15th largest economy in the world, right? And remember California's effect on the car industry, right? So here we are. Colorado has their Privacy Act, which is more restrictive or more GDPR-like than California. It becomes effective, 15 months from now. The Virginia law becomes effective, at the end of the year. And Utah is going to, I think, pass something pretty soon. And 25 states have legislation that's proposed. So what's these rights under the CCPA and how do they look to the GDPR? Compare the right, we'll take one example, the right to delete. The CPA's is less protective than the GDPR's. And here's a nice way to sort of think about it. Like under the GDPR, businesses must delete info obtained from you, info about you obtained from others, and inferences about you, right? So the GDPR is thinking, we're going to protect all of your privacy data, right? It's this sort of fundamental right. So that's how they think about it. Well, California only compels deletion of the first category, that which you gave that business. Virginia requires the deletion of the first two, and Colorado is, like I say, more like the GDPR because they require all three. So who's, protected? It's, it's supposed to protect those Californians, right? And what are the rights? To be informed, right? Transparency, what's going on. To delete, right? And to opt out and some non-discrimination. So if you exercise your right, like if you're a whistleblower or you say, I don't want to do that, right? You shouldn't be discriminated against in whatever that business is. Who must comply? Well, it's a business. And then one of these three, you have to satisfy one of these three, over 25 million, or you buy, you're trading in a lot of California data, or it's your business of, trading in the data. So if you're covered, then California comes to you and says, what do you have to do? Well, you have to provide all these details about what was going on in the last 12 months, the type of data collected, how the data was collected, why the data was collected, and types of third parties the data was shared with. And I ask you, 5 minutes? Oh, Lord. Okay, so, got to think about this. So, think right now, if someone came to you and made that request to your business, what would you do? Are you prepared, to handle it, right? So I will tell you the Attorney General is enforcing the CCPA, but mostly it has been behind the scenes. They have not brought a case in the public records. They have not, they're going to people, unlike the FTC who goes to people and then, does their consent decree. They're going to people and they're just issuing these sort of anonymous descriptions. Oh, and I don't have time to go through them all. this grocery store wasn't doing this. They changed their privacy policy. Now they're doing this. It's all about privacy policies. I'm going to get to one thing. So let me just say this. If what you do when someone says, well, we need a privacy policy, go copy that other guy's privacy policy. You might as well just open up your checkbook, because you have to do the homework to figure out what are you doing in your business and define your own privacy policy. I'm not saying you can't look around the industry and see what other people are saying, but if you're not designing your privacy policy for what you're doing, you're just asking for the FTC or someone to come in and, class action or whatever to come after you. So let me get to one. Okay, so on Louisiana, this is this joint committee that was supposed to put out a report in January, but they didn't. They had Microsoft, a gentleman there, Ryan Harkins, who is sort of Microsoft's lead guy on promoting legislative efforts and coordinating and all that. And he testified up in Baton Rouge on it. You can go look at the transcript. It is interesting. By the way, Louisiana does have a database breach law. Don't forget about that. It's you have an obligation to reasonably protect the data, right, and to give notice. I will talk about the cases. The privacy policy. This is, again, I just said this. Do your homework. Don't copy. Right? Do your homework. Come up with your own privacy policy. We talked about the enforcement trends in the GDPR. Now everybody sees their cookie. Now you know about that from the GDPR. And this is the gentleman, Mr. Shrem, who has, how much time? 3 minutes? Okay. Who used to work in Silicon Valley, went back to Europe, Switzerland, and basically we had a huge hand in writing the GDPR. And he has 2 technical knockouts. He has twice challenged the arrangement between the United States and Europe for transferring data across. The first was called the Safe Harbor, and the second was the most recent was called the Privacy Shield. And Mr. Shrem challenged those. Why? Because the ability of our government to intrude into so many databases, whether it's Google or Amazon or whatever. And I'm not here to say it's good or bad. I'm just saying there are many times where the government has access to the data and you don't even know they're accessing your data, or they're doing it in a way where nobody knows that they're accessing the data. And because of that, basically the European Union has said there's no way that anyone in the United States can really protect this. There's no way we can have an agreement to transfer data from Europe across to the United States because of the power of our government to get to the data. So there is a movement now, obviously, to work out some new privacy shield. The only mechanism you have right now, and this is, what's the reasoning? It's a doozy, right? It's like, because what the government can do, there's no way to ever get something in place. And I just want to, if I can get to it, right? Here's what you're left with, which are the standard contractual clauses if you need to bring data or use data from the European Union. And I know it's pretty small there, but it's very onerous, or you might think it's onerous. The European Union doesn't think it's onerous. This is what they expect under the GDPR, right? And the one I highlight there is you have to waive your jurisdictional challenge, because there's a huge issue, right, as to whether the GDPR, while on its face says they can come sue someone or investigate someone in the United States because of European Union data, can they really do that, right? And that really hasn't been tested, although they find a lot of people, and people have chosen not to challenge that. But if you use standard contractual clauses, you're basically giving up that argument. You were agreeing to do it, which is what you were doing under the Privacy Shield through a surrogate. You were giving up your right. The European Union was waiving their right to come sue you because you were allowing the Department of Commerce here to basically do the same thing, which I guess was a deal. At least you have someone in the United States investigating you, not the European Union. So what's the, now big tech is all into trying to get something passed because they've got all these hodgepodge laws being passed, right? And so there is I know, I'm done. There is some, will it happen? I don't know. There's a number of proposals. A lot of people say now, hey, this is all, big tech wants it now because they're losing control of it. I don't know. You can go read all about it. We have the SolarWinds attack. We had the annual Hack the Army event now. We had the Colonial Pipeline. We have, President Biden's statement on security. There's a new statute that isn't a statute yet, passed the Senate for what's already the CISA group. And it's given a lot more power to CISA. But every business, basically over 50 employees, would have to report ransomware activities. So, is it a good thing, bad thing? I don't know. It's trying to be a clearinghouse to collect all the information, all the ransomware. I mean, that you can understand that might be a good thing, but civil libertarians, you might think different. All right. There's also one other act, and actually our senator has proposed this, or one of them, which is called the Fair Terms of Service, like simple language, English language in the terms of service. I've written a lot of terms of service. You've read a lot of terms of service, or probably you haven't read all the terms of service, right? You go on, you sign up for an account, it says accept, and nobody reads, right? But they're very burdensome, they're very long. I've written them, right? That's what it is, right? And so this is an act to try to change all that and make terms of service more readable. By the way, they just passed, the SEC just put out some more rules about cybersecurity. Know where your data is. That's what that one is. Where in the world is your data, or who you're dealing with. And don't forget about NIST. It's a great framework. And I think I will end there. How many minutes am I over? 2. Oh, I'm doing great. All right. Okay, so until 9:35, we have a break. If anybody has any questions, I'll be up here for a little bit, and then I need to get in the other room. So, okay, guys.